and reading the policies that the United States was adopting and adopted towards Alaska Natives, reading the Treaty of Cession and seeing what it said, and concluding, oh, it's illegal. There are tribes in Alaska. Nobody said it. The tribe word was not used by anybody. And that's the crux, as we'll see. The crux of the legal relationship of the federal government to Alaska Natives. The legal crux of it is the existence of tribes. And I thought, well, I bet it'll be 50 years before this ever gets straightened out, before before the tribes are actually recognized legally. But in fact, they had already been recognized by the actions of the United States for the last, by then, 50 years. Or going back to the Treaty of Cession, I think you can say back to then they were recognized in the Treaty of Cession. And so the book actually concluded, there are tribes in Alaska, and they will be recognized in one of three ways: legislatively by Congress, executively by the executive branch, or through the courts. And within 20 years, all three of those things had happened, not without great struggle, I might add. But it was because the leadership at the time knew they had to get control of and understand this history that book got written. And it happened, its virtue is really, that it collects all of the, it's not just about the tribes in Alaska, it tries to collect between two covers the laws that apply to Alaska Natives. The first time I wrote that book, it took a year, the Native Foundation. The second time, and another mentor of mine, Dennis Demmert from Clark, was the head of Native Studies at the University in Fairbanks. They commissioned me to teach and rewrite it as under its current title, and finish it, do some more research on it. That took 2 years. The next time I wrote it, it took 10 years, and a co-author, David Volley. And the next time after that, we took another 10 years to revise it. It just was issued as a third edition in 2012. But that explains that there's been complexity. It's been the issues have evolved since its first writing, and that's some of which we'll talk about today.
David, could we stop you for just a second and ask you to put on a mic so we can videotape you?
No, there we go. Okay. Part of the point of that story is that Native leaders and Native people have always been leading in Alaska and leading towards their destiny, in my view. And they may even go back on history and say that too. And I really begin to prefer the term indigenous peoples to describe indigenous peoples instead of natives or Indians or Eskimos or any of that stuff. But they have been struggling against the greatest power in the world for ever since 1867 to deal with these issues and to realize their claims. And I think we'll be struggling with that far into the future. But I think we want to understand and have a kind of a basic foundation of the law and why there are Native claims and why there is a unique position and a unique political relationship between indigenous peoples and the United States. And this may be a repeat for people, but it'll be fairly quick, and I want to be sure we all understand the same things. So let me ask you, in this country, where do we find the law? Where do we look for the law? But what are the places we look for when we think, well, I need to find out what the law is? No? Go ahead. Case law. Case law. I mean, what do you mean by case law?
There's been a dispute. A judge or a jury or somebody else says this is how it will be settled, and therefore everybody following later will follow the same path.
Okay. And we call that the common law. It's unique to the British Empire and former colonies of the British Empire, of which let us not forget we were one. And it is a law that is made by the courts based on custom. Now, the courts decide other things of statutory meaning and so forth, but these kinds of laws are made out of the custom and the history and the practice, where Congress hasn't enacted any law. But people have behaved in a particular way for a long time, and the dispute comes up about what is the correct interpretation of these actions or their history. And a court, under the common law system, has the ability to interpret those actions in that history and to write an opinion that then becomes the law. And so in order to determine the law, you have to know this case or the history of cases that, after it. That's one of the real reasons lawyers make a big living, is because they know where to look for these cases. Okay, but the common law is very important in the field of Indian law, because there were no statutory laws related to Indians for the most part until the 20th century. Okay, other forms of law, where do we find them? Yeah.
Can it be in precedent?
Precedent?
In best practices?
Well,
Sometimes.
precedent is what you actually get from the common law decisions. That's right. And those.
I was specifically referring to land best practices in management, and I didn't know if there was some.
Not so much, unless it is converted into some rule or statute, does it actually become law. Those might become, I don't know if I'm tracking you here, best practices might be practices and good management practices, but they don't have the force of law that can require you to do something or interpret the legality of what you've done.
Hopefully they're based on.
Well, not always. You know, maybe I don't fully understand the question either. But, okay, any other sources of law? Yeah. United States Constitution. It's actually kind of the measuring stick against a lot of federal law and now state laws too. But they have to satisfy the requirements of the Constitution, right? Denise? Statutes and regulations. So the Congress passes laws. Those are statutes. The legislature passes laws. Those are statutes. The governor or the president, the executive branch adopts regulations interpreting the statute. Those have the force of law too. So that is in our system kind of where the law lies. In these three branches of government, the judicial branch, the legislative branch, and the executive branch, and they're all playing their own role. But now let's go back to the Constitution. Now, the Constitution, let's remember, is a grant of limited power. From whom? Who has the power of government? Where does the source and the legitimacy of government come in this country? The people. The people. We, the people, in order to adopt the Constitution. Now, the Constitution then delegates to the legislature, to the Congress, the power it's going to have, and to the federal government, the executive and the legislative and the judicial branches, the power they will have. And if the power isn't in the Constitution, then Congress can't enact a law related to that topic. Now, we lose track of it because the Congress has more money and has more power and has sucked into itself a lot of lawmaking authority. But the reality is, unless the Constitution grants the power, the Congress does not have the authority to do it. Now, so the powers are granted in Article 1, Section 8 of the Constitution. There's a whole page, it takes a page and a half. But the first powers are to collect, and Congress will have the, by the way, I have a handout here. There's a one-page handout with two sides, okay. And Congress has the power to collect taxes, duties, imposts, and excise taxes, and to pay the debts and provide for the common defense of the United States, to borrow money on the credit of the United States. First power to Congress, to borrow, go into debt. Now, what could be more American than that? The second power, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, the grammar is, to me, significant. I'm not sure that any court has made anything of it, but you'll see that it's the commerce is to be regulated with foreign nations among the states, which are among the part of the United States which this is the Constitution for, but with the Indian tribes. I mean, they are in the same kind of grammatical construction, if you will, as the foreign nations. In other words, they are outside of the United States. They are not they are not among the several states. Now keep in mind, this is 1789, in a world in which the foreign nations were trying to co-opt the Indian tribes to get rid of this United States. on the north and the south and the west and so forth. I mean, the tribes were often the allies. The British burned the White House in 1812. It wasn't quite over, the revolution, until they gave up and went home in 1812. But the Indian tribes were often the big concern of the United States of internal security and foreign policy was maintaining peace with the Indian tribes so that they would not be allies of the European nations that might attack the United States. And so that was a good part of the history, of the early history of the United States. Now, this is the power. But what's the significance of the power is Article 6 of the Constitution, which is often called the Supremacy Clause. Which provides that the Constitution and laws of the United States, which shall be made in pursuance thereof. So you have to have the laws made in pursuance of the Constitution. See, if the laws are not made pursuant to the Constitution, they're not legitimate. But as long as they're made pursuant to the Constitution, they shall be the supreme law of the land, notwithstanding. And judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So that means if Congress has the power, makes a law, then no state constitution or state law can supersede it. Right? So this is very important in the field of Indian affairs because the only source of power in the field of Indian affairs that Congress has is this one, to regulate commerce with the Indian tribes. And so when they pass a law settling a native claim, they are regulating commerce with the Indian tribes. And that is the supreme law of the land. It doesn't matter what the Constitution of Alaska or the laws might say. If they had settled claims in Alaska granting exclusive hunting and fishing rights to Alaska natives or priority hunting and fishing rights to Alaska natives, as is the case in Washington State and many other states under the treaties in those states, it wouldn't matter that the state of Alaska's Constitution prohibited discrimination on the basis of race or required X, Y, and Z when it comes to the use of those resources. That would have been the supreme law of the land. So this is the way the Indian law works under the constitutional system. Congress has the power to regulate commerce, and that has been viewed as, in the case of Indian law and Indian affairs, plenary, P-L-E-N-A-R-Y. Now that's not absolute power, but it's complete power. So Congress has plenary, complete power under the domestic laws of the United States to regulate commerce with the Indian tribes. And what's commerce? Well, it's anything really. There's been no limit to it in the history of the country. So anyway. And remember, when the Constitution speaks of the indigenous peoples, it speaks of tribes. So that big tribes, this word, becomes the operative legal concept that connects the United States to the Indian tribes. Now, there's no other minority in that Constitution that doesn't say, slaves have a unique relationship with the United States. It doesn't say Hispanics or anybody else does based on their race. It says the Indian tribes. Yes, sir.
So tribes, being the operative word there, probably hidden within there then is what actually makes up a tribe or what they do makes them a tribe.
Yes.
So regional corporations have been described as tribes. Village corporation also, as well as tribes.
Yep. In Self-Determination Act, but they're tribes for certain purposes in those statutes in those 20th century. Right. Now we can we can talk a bit about tribes here today. I mean, the focus is this is the legal effect and the legal issues under the Claims Act, and but the position of tribes is one of the legal issues under the Claims Act that we will get to. Okay, so this is how it works, and that's why, frankly, that's why you have an Alaska Native Claims Settlement Act. But let's turn now, and we'll come back to that, to the other side of this story is the excerpts from the case Johnson versus McIntosh. Now, everybody heard of the concept of Aboriginal title? Anybody, well, maybe, do we know what it means? I'm going to take no for the answer if nobody says anything. Okay. Oh, that's fine, because I didn't know what it meant either for a long time. This is a matter of common law. It's a common law principle that comes out of a case in 1823 out of the U.S. Supreme Court. And this is Johnson versus McIntosh, and you have an excerpt of it here. Let me give you a little bit of background to this. This is a dispute over land between two people who dispute who owns land in the Ohio River Valley. Now, you'll notice right off that Johnson and McIntosh probably aren't indigenous people. And in fact, Johnson had acquired a lot of land from the Illinois and Pankenshaw Indians, and he'd bought it from them in 1776 or so. The date is significant because about then the War of American Aggression, as the English came to call it, broke out, and Mr. Johnson was a sympathizer supporter of the king, and he returned to England as an absentee landlord now of this land in the Ohio Valley. Then George Washington and others, of course, were interested in the land in the Ohio Valley too, to acquire it from the Indians because it was valuable land. And Mr. McIntosh was a recipient of a land grant from the federal government as a result of his service in the American Revolution of this same land, some of the same land that was now owned by Johnson but now claimed by McIntosh. And the matter went to court. Now, there's some history here that this all was cooked up, this whole case was cooked up to clarify who had what kind of title to these lands in the Ohio Valley, and so that the Virginia military veterans could be able to get land more freely. But anyway, we'll just take it at face value. So Johnson owned the land. McIntosh claimed the land. Johnson was in London, and he had a document of title first in time from the Illinois and Pankenshaw Indians, and McIntosh had a document of title from the United States government. It's going to the United States Supreme Court. Who's going to win? Anyway, this is what John Marshall says about this situation. He analyzes now what is the right, who has the superior title to this property, the fellow that got it first, who lives in London, or the fellow that got it later and from the United States. On the discovery of this immense continent, the great nations of Europe were eager to appropriate to themselves as much of it as they could respectively acquire. But as they were all in pursuit of nearly the same object, it was necessary to avoid conflicting settlements and consequent war with each other, to establish a principle which all should acknowledge as the law, by which the right of acquisition, which they all asserted, should be regulated as between themselves. Acquisition of what? What are they acquiring here? From whom? Okay, but now Johnson and McIntosh aren't Indians, so how does that come into play here? This principle was that discovery gave title to the government by whose subjects or by whose authority it was made against all other European governments which title might be consummated by possession. Now these are elegant words. Every single word means something in a sentence. The principle of discovery is the rule of discovery. Rule of discovery at the time it wasn't written down, as far as I can tell. It was kind of a common assumption or a common principle developed in the European powers as they explored the world and started to claim it for themselves. And that was that the first Christian land, convenient that it had to be Christian in order to exercise the rule, to discover a non-Christian land acquired the first right to it, as among other Christian nations. So when it came to Spain's claim to the New World, the Pope divided it between Spain and Portugal. So you have Brazil as Portuguese because of where the line was drawn, and the rest of the world was supposed to go to Spain by right of discovery. Well, the English took some exception to that and quickly got over to the North American continent, discovered some stuff. Now, how is these? Now you see, it says the title. They have title, but they don't have complete title, do they? It's title, not ownership, but it's title to the government who's subject to acquire it against all other European governments. It's just that kind of title. It's not title against the world, just title against other European governments. But it's not even complete. It's which title might be consummated, completed by possession. So you see, this sentence doesn't say the discovering power owns the land. Don't get title confused with ownership. Property is a kind of a wonderful thing. If you're a lawyer anyway, it's considered like a bundle of sticks. That's what your property professor will tell you. It's a bundle of sticks, and each stick represents a property or an aspect of property that you can lease. You can have an easement over it. You can rent it, and if you have the whole bundle of sticks, you own them all. Then you got fee simple property. But you can take it out and parcel it out to different pieces. Different people can have different parts of your property, and so that's what Marshall is saying here, is that the property is all that your discovering power acquires is the bare right to acquire this property, which might be consummated by possession. The exclusion of all other Europeans necessarily gave to the nation making the discovery the sole right of acquiring it from the natives. So now we got a monopoly. The discovering power has the sole right to acquire the property from the natives. Now you can see this is where it's going to be consummated by possession. There's an acknowledgement that the natives possess the land, but the discovering power claims title to it. And they have to consummate that title and ownership by possessing it from the original inhabitants. All right? And only the one discovering power has that right. So what does that do to the value of the land of the original inhabitants? Keep that in mind. So acquiring the soil from the natives and establishing settlements upon it. Those relations which were to exist between the discoverer and the natives were to be regulated by themselves. Now we're shifted from the rule as it applies to the discovering power and the other European powers to the rule as it applies between the discovering power and the indigenous peoples. Regulated by themselves. How do they do that?
They strike their own deal.
What's that?
They strike their own deal.
Struck their own deal? They often went to war. That's how they could regulate it too, by themselves. But they would negotiate treaties, and often as a result of wars or the threat of wars. So it was regulated by themselves. Okay? But keep in mind, the only party the indigenous people now could deal with under this rule is the discovering power. They can't go off to Spain and say, hey, will you make us a better deal? We'll sell it to you if you give us some more money, or we'll give us a better deal than the United States will. That won't work. There's only one buyer here. It's an option, but only one buyer can have it. The rights thus acquired being exclusive, no other power can interpose between them, but just between the Europeans. In the establishment of these relations, the discovering powers and the indigenous people, the rights of the original inhabitants were in no instance entirely disregarded, but were necessarily to a considerable extent impaired. Aha. How were they impaired? How does this rule that grants a monopoly to acquire the land from the original inhabitants impair the rights of the original inhabitants?
Because they only have the option to sell or give out.
Right. Yeah. They have no bargaining power. They have no legal bargaining power. So they were admitted to be the rightful occupants of the soil with a legal as well as just claim to retain possession of it and use it according to their own discretion. But their rights to complete sovereignty as independent nations were necessarily diminished, and their power to dispose of the soil at their own will to whomsoever they pleased was denied by the original fundamental principle that discovery gave exclusive title to those who made it. So, Mr. Johnson had title from the Illinois and Pankenshaw Indians. Mr. McIntosh had title from the United States. The United States, I didn't mention this, had a treaty with the Illinois and Pankenshaw Indians to acquire this land. And so, but the United States, through its treaty then, according to this, had the monopoly and the only legal right to acquire the property from the Indians, and therefore the title of the United States was legitimate and the title of Johnson was not. And that is the result of the rule of discovery. And what is aboriginal title? It is the exclusive right of use and occupancy not complete fee ownership, but indigenous people under this common law rule and the domestic laws of the United States have the exclusive right of use and occupancy of the land, all the land that they actually use and occupy, which was basically all the United States. And that is a form of title. And if you trespass to that title, if so you're not the United States and you are a third party, you come in and you use it, you're trespassing to it. And the United States has an obligation, as the law evolves, to defend the indigenous peoples against that trespass and to throw out the trespassers until the Aboriginal title is cured and the claims are resolved. While the different nations of Europe respected the right of the natives as occupants, and now see they're occupants, they've gone from owners to users and occupiers. They asserted the ultimate dominion to be in themselves and claimed and exercised as a consequence of this ultimate dominion a power to grant the soil while yet in possession of the natives. These grants have been understood by all to convey title to the grantees subject only to the Indian right of occupancy. So the United States can even convey property to grantees like maybe Mr. McIntosh, even before they've got the treaty with the Indians to resolve the title. But that title is still subject. That Mr. McIntosh couldn't take possession of the land until the United States had consummated by possession by a treaty with the Indians to acquire the land from them. So in Alaska, well, there were no natives in Alaska, that was the theory, and they didn't have any rights, that was the theory, for many, many years. And the United States granted lots of land to people for homesteads, and, well, then they granted land to the state, didn't they? And the state had, well, what did they have? Well, they had Prudhoe Bay. Wow. And they were going to put a pipeline down from Prudhoe Bay to get the oil out. But what do you do about native claims? What if there's an exclusive right of use and occupancy to all the land in Alaska by the indigenous people of Alaska? Are you trespassing if you start to pump the oil out of Prudhoe Bay and send it down the pipeline without having resolved that claim? Yeah, yes you are. What could be the price of that? Well, you could get down to the end in 50 years of litigation, you might have to pay for the trespass by disgorging all of the profits. So there becomes an incentive in 1971 to settle the native claims in Alaska because of the claim of Aboriginal title. And so that's why I want you to we all should understand what Aboriginal title means and how significant it is. Now, yes?
Settling that functionally meant educating those that dwell there or that used it or whatever to look at land law through the federal government's eyes.
Well, that comes down the road.
I mean, essentially, that was the portal that you had to go through. Defining that made everybody line up to look at land law through that.
It's a very, you have a very good point. And that's actually where we're going to go next. So before you get ahead of me, let me get there.
Maybe just a quick question. I'm trying to figure out how this, so discovering nations and the European nations have this theory that they worked out, their own agreement.
It's a law. It's their law, they made it.
But, and now there's the Aboriginal people that don't have anything to do with it, and they don't have to recognize it. So the idea that somebody has a monopoly on their land, maybe it's just sort of the practical effect of all of this stuff, but the Aboriginal people don't need to deal with them. They're not party to that agreement, so it's kind of like, whatever you guys agree to, we're not going to apply.
And first, it's unfair. Let's get that out of the way.
Yeah.
This is the law,
But I'm thinking
but it's not
from a
fair.
legal standpoint, how can it commit them? I mean, maybe it just comes
How can
out
they?
of warfare.
Yep, that's exactly right.
Okay.
That's exactly right. If the Aboriginal people had a thermonuclear device or something that they could really have repelled the United States, they wouldn't have to give up any of the land. They wouldn't have to accept this unfair principle that they now no longer have ownership of this property. They only have exclusive use and occupancy. See, I mean, it's not fair. It's not fair. It's not just. Does happen to be the law that has been created in this case. and that governs the affairs of indigenous peoples vis-a-vis the United States and their lands. Now, we won't get into it, but the United Nations Declaration on Indigenous Peoples, Rights of Indigenous Peoples, is inconsistent with this principle. But that's now a 21st century analysis of indigenous rights. And who knows where that leads. But keep in mind, it exists, and there is a United Nations aspirational statement that would suggest that these laws, this principle of law that confiscates lands from indigenous peoples, is not should not be recognized under international law. But that's, there's no international law on that yet. It doesn't bind the United States, but it gives you kind of a template against which you can measure the justice of some of these principles. I'm not here to throw bombs. I'm just to say that there are principles at work here. There's law, and you don't have to, just because it's the law, you can question whether it's fair or not, whether it's just. You still have to follow it, but maybe it will change. Okay, so here is, let's say, room here. Here's a territory of a tribe. I'm going to just put a little river running through it. And here is the tribe's territory. And it controls this territory. It's hunting and fishing and resource rights, just like any other government of people would, or community of people would, by its own military abilities and its population and so forth. Now comes the United States. And usually its people are ahead of the government. They're invading it by force of greed and aspiration. And so here comes the United States people conflicting with the Indians on their property. So what happens? The United States negotiates a treaty with the Indians, and this is what it does. It extinguishes Aboriginal title. To usually most of it, a lot of land. Extinguishes that Aboriginal title. Let me say this, let me say instead. And it, the United States pays money to the tribe, or its equivalent. In the 19th century, it would have been guaranteed health care, blankets, rations, and so forth, or money too. But that's paid to the tribe in exchange for extinguishing the Aboriginal title, some monetary amount. And then the tribe is reserved land. And that's where we get the term reservation. Okay? So that's a typical settlement in the lower 48 when there were treaties and so on. And over this reservation, the tribe has the power of proprietary. In other words, it owns the land and it governs it. So it has proprietary and political power over the land. Maybe I should say political. Proprietary and political power. Now, there's also the fact that the federal government claims a trust ownership of the land and for the benefit of the tribe. I'll tell you, you look at these treaties and you look at the documents associated with them, none of them transfer, I don't know of any of them that transfer land to the federal government in trust. But that's the rule anyway. The government holds the land in trust, so it holds title to the land in trust for the benefit of the tribe. But as time has gone on in the later 20th century, the reality is, especially with change in law, that the tribe has control of this land, both as an ownership and as a political matter. Now, what happened in the Claims Act? Well, it's sort of like that. And so now here you have, throughout Alaska, 200 villages. I don't have enough time to put 200 villages up there. So there's 200 villages or so throughout Alaska. Alaska becomes a state in 1959. Down in southeast Alaska, there has been cooking along ever since 1935, a claim by the Tlingit and Haida Indians for the taking of their Aboriginal title by the federal government to southeast Alaska. The creation of the Metlakatla Indian Reserve, set aside the Tongass National Forest, and the Tlingit and Haida had gone to Congress and gotten a law passed that allowed them to sue the federal government for their claim to Aboriginal title. Now, they had to prove they had Aboriginal title here. And the assumption was that there were no Indians in Alaska, that they did not have any land rights in Alaska. That was the conventional wisdom. But you read the Treaty of Cession. I don't have it here now, but it's Article 3 of the Treaty of Cession. It's in the book. Says that Alaska is divided into, it divides the land up, and then it has Article 3. It says, the inhabitants of Alaska, except for the uncivilized Aboriginal tribes, according to their allegiance, may return to Russia or become citizens of the United States. The Aboriginal tribes shall be subject to the laws that the United States enacted with respect to the Aboriginal tribes of that country. Now that's what the Treaty of Cession says. It uses the word tribe 3 times. And the Constitution uses the word tribe. The treaty uses the word tribe. It must mean tribes. But everybody ignores what this article of the treaty. Nobody ever mentions it. It's all like it doesn't exist. There is no, Aboriginal title doesn't exist in Alaska. So damn, it'll be bad for business if we have to deal with these native claims. Ernest Greening and others just think it's not true. 9 months after statehood, the Tlingit and the Haida win their claim in the Court of Claims to the claim of Aboriginal title to all of Southeast Alaska. Now, they don't get much money for it in the end, $7.2 million, because it was valued at the time in 1901 when Congress took it for the Tongass Forest and no interest is paid and so forth. But that was the principle was established, that indigenous peoples in Alaska had a claim of Aboriginal title. And that was not lost on the young men and women that were coming out of Mount Edgecombe and going to college a couple of decades later. That there was a claim of Aboriginal title in Alaska. They began to study these things. A young man named Willie Hensley took a course from an older man named J. Rabinowitz, who happened to be the Chief Justice of the Alaska Supreme Court, right in Fairbanks. And Willie will probably talk to you about this. I won't tell you. Anyway, he wrote a paper for this class. And his paper was, what rights do Alaska natives have to their land? And he laid out this whole theory, the law of what this Aboriginal title claim and what it is. So you see, I believe the young leadership at the time became informed about these claims and began to assert them. But how it happened in this claim settlement? Well, sure enough, the Native Claims Settlement Act, 1971, extinguishes Aboriginal title in Alaska, which becomes a point of dispute later on. So the Aboriginal title claim is extinguished in Alaska, which is Alaska and 3 miles out to the coastal waters, 3 miles out. That's in Alaska. So the claim is extinguished. To 365 million acres. But instead of the land money being paid for the extinguishment of the claims to the tribe, it is paid to corporations. And the United States and the state of Alaska pay $962.5 million to extinguish the native claims in Alaska to 365 million acres of land. quick. How much is that per acre? $3.
Yeah.
$3. Now, this is the most generous settlement in American history. I'll leave it to you. I mean, $3 is a pretty good bargain for the United States to have acquired free title to all the land in Alaska, which in 1969 returned $900 million to the state in a single lease sale. And the corporations here kept 45.7 million acres. Now everybody says 44. It isn't right. 45 plus million acres is how much land the native claims settlement resulted in. Don't believe the 44 million acres. You know, I got the chart in my book, and the BLM added it up. It's not 44. Just gripes me every time I see it. Okay. But that's the main difference, isn't it? Now, what has happened over here to the tribes? See, they didn't get the land, the reserve land, or the right to the proprietary right, or the governing authority over it. It's with the corporations. Now, of course, at the time, there were no tribes in Alaska. I mean, that was the theory. There were no tribes in Alaska until. Well, there were always tribes in Alaska. There always have been, just like there were tribes in the Lower 48 before there was any law about it. Tribes are, well, first, the tribe, the word, is a colonial word. It's our word. It's not the word that indigenous peoples use to describe themselves. And I predict it will not be the word that will be used forever either, because these words change, and language means something. And this will change because it's the wrong word to describe the rights of people. But that's the word we have now, and it's the word in the Constitution. It's the word with legal significance, tribe. At the time, the Claims Act describes a village as a tribe. It uses the word once to define village as a tribe, or a band and other things that might be associated with it. But that's it. And so there's no mention of the tribes in the Claims Act. Well, that means one significant thing that means is that the Claims Act didn't touch the existence of tribes. It didn't deal with them. It didn't terminate them. But in order to terminate a tribal existence, Congress has to speak specifically to do so. It didn't do that. And that was one of the realizations I had researching this book, was Congress did not terminate the existence of tribes. But that difference here between this model of a tribal settlement and this model, and I'm not trying to say this is bad, this is good, that's bad, this is bad, that's good, whatever. They're just different models, and it's important to realize that they are different and why. Because it explains why there are issues now between tribes and corporations over these kinds of claims. See, the people in the tribes often feel they were left out of this deal. They weren't consulted. Their land, and the tribe, of course, is the entity with the Aboriginal claim. I didn't mention that, but it is the Aboriginal title is a tribal claim. It's a claim of a community of people. Individuals don't have Aboriginal title. Communities of people called tribes have Aboriginal titles. And before the Claims Act was passed, one of the motivators to settle the claims was the protests that the tribes, the villages, filed against the state's selection of its lands. So when the state was selecting its lands in 1959 going forward, and then in the mid-60s, the native people began to organize for their own claims and realize what they had, they went out and they filed protests against any future native conveyances or selections by the state of its statehood lands. And the Secretary of the Interior, who has the trust responsibility to protect Aboriginal title, got the picture. And that was Stuart Udall. And he froze the state of Alaska's right to select and convey lands until the claims were resolved. And he got upheld in court. So now the state can't, in 68, 69, the state is stuck. They can't select their lands because it's illegal, because they're going to be taking Aboriginal title until the claims are settled. And here are the oil companies saying, my God, we got these leases, we got to get the oil out, we have to settle these claims or we're stuck, and so there we go. You know, the door opens to settle the Alaska Native claims. And they were settled on the model of a corporate model, and which was unique. It's a unique model of settling the claims. It certainly, well, you all are here, are testimony to what the Claims Act has done. It has created corporations and institutions, not only profit corporations, but there's a plethora of nonprofit corporations and health service corporations, and then there's the tribes, and you have all this heady institution, mix of institutions, and including, it ended up allowing for rural municipalities to be formed, because an Aboriginal title had been cleared, and their resources could be developed, and they would be the tax base for largely native, indigenous rural municipalities. So all that happened because of the Claims Act. You know, I think that if you look at settlements in the lower 48 with reservations, it doesn't seem like there's quite nearly as many people going to college and coming back and taking over and operating their own institutions as effectively as appears to be the case in Alaska. And one has to, and I don't think that Alaskan Natives would be generating 1/4, probably more now, of the gross domestic product of Alaska if this settlement had not been in this form. So the settlement, in my view, delivered a tremendous amount of economic and power and capital into the hands of indigenous people. And in a capitalist democracy like the United States, if you have capital, then you have power. And this is the only settlement that I know of that actually delivered real capital into the hands of indigenous people. And look what's happened. I think it's tremendous what's happened. But it hasn't settled everything, and especially in the villages. And we'll talk about that now. Yeah.
Just a quick question. I'm trying to follow I hope I can articulate this right. So, going through the Land Claims Act, the settlement of cash and lands was with corporations and not with individuals who make up the tribes.
No, it's a good point. It was not, don't think of tribes as being individuals. Tribe is a corpus, it's a community, it's a government. Okay. It's like the United States or France. You know, I mean, it is people, but it is not just the individuals that you settle with in a tribe. It's the tribal government that you settle with. You know, when you have a treaty with a tribe, it's the leadership that signs the treaty.
Okay, so the corporate entities were in lieu of that, but they were a valid vehicle for this. I guess I made a note here that it sounded like there was a question whether whether Aboriginal title was actually settled with the right party.
But okay. No. But remember, Congress has plenary power. It has complete power in this field to regulate commerce with the Indian tribes. So the law has evolved a bit, but as long as Congress says you are an indigenous group with whom we will settle these claims, they can do it. They have plenary power. And so Congress has the power to regulate commerce. This is most assuredly regulating commerce, settling a claim to land. And they could select, they could decide, we will identify corporations to own this land. Now, they never called the corporations tribes. And you know, there's kind of a crabbing going now. Now the corporations trying to say we're tribes. And then for some purposes, they have been designated as tribes too. We can talk about that. But there's no problem. I mean, corporations can be they can be the recipients of this claim by Congress, and it's legal. I don't think it's subject to challenge.
So as a follow-up to that, we had our last speaker was talking about it's kind of the concept that the settlement, I guess if I was just to rephrase it for him, the settlement was with the original people that were shareholders in those corporations, and that these same the settlement, if you will, and whatever was given up does not apply to people that weren't a party for that. So everybody who is a non-shareholder, which even a lot of people in this room are not affected. They didn't settle under this, so they didn't give up any right.
Well,
I'm
no.
saying that exactly right,
yeah.
but what do you think?
Well, I think Aboriginal title has been extinguished. I mean, it's gone. It's gone. Nobody else can claim it. It has been extinguished.
Okay.
And so no other individuals that survive today that are not the shareholders and so forth and so on have a claim to the Aboriginal title in Alaska. There's no leverage. I think that's the law.
Okay.
So it's similar to like if my dad owned 5 acres and he sold that 5 acres before I was born, I couldn't go and say, I get this 5 acres.
Right, that's right. That's a good point. That's right. The claim has been extinguished.
Yeah, so an Aboriginal title, obviously, we're dealing with land title.
Mhm.
You know,
And
so
all the
I don't
resources
know,
that go with it.
You know, we were talking about this in our group. Did we have another part of that? I don't know.
I think it was subsistence.
Subsistence,
Maybe
yeah.
it was the other factors other than.
Okay, let's go back here and I'll just draw you a little diagram of,
I don't want to get you off track.
well, no, this is on track. I mean, I think, but we really need to be sure we understand the framework, at least the framework I'm talking about, because it's in my head, and I'm trying to get it into your head.
I think Scott was mentioning this is something that one of our previous presenters was sharing, but I have the distinct feeling that he was talking from a UFIC worldview, not necessarily from American legal point of view, right?
Well, you,
Whether or not Aboriginal title and rights is still there.
Yeah, yeah, I think it was from more from that perspective, but he made the words he used was that they didn't feel like they had settled or obligated under the Settlement Act as the next generation.
yeah. Well, I don't think that'll win in court. I mean, you know, in the courts of the United States. But I believe it's a legitimate, I mean, I believe it's probably it could be a heartfelt view and a view of the way the world is. In fact, because if you're on the ground out in the Yukon Wildlife Refuge or the Yukon-Kuskokwim Delta hunting for birds, well, you know, that's the world. You know, it's not the world of this settlement. It's the world you live in, and you have the right to those animals if they'll give themselves to you. It's between you and the animal. It's not between you and any dang federal government. I would think. Okay, so. This is all kind of wrong here. Okay, these are the three generally ways in which I think indigenous rights are cataloged. They're land, which means the resources, the minerals and other resources of the land. This word, I put it in quotes because I don't like it either, but it's subsistence. Hunting and fishing is what it meant before the days of Alaska and this controversy in Alaska. And sovereignty. Those are basically the core indigenous rights, that they exist before there's any contact, before there's any rule of discovery. And then along comes something like the rule of discovery that is imposed upon it. Put that in quotes, of course, because Spud Williams will tell you they didn't discover shit. Anyway. Now, after the rule of discovery, we don't have indigenous rights. We've got something called Aboriginal title. And it's not a complete right of use of ownership. It's use and occupancy. But it's exclusive use and occupancy, and that's the key. You know, if it is exclusive use and occupancy, that means nobody else can be using and occupying it until the aboriginal title is extinguished. So it is significant. That's why there can be trespass claims against aboriginal title, because it is an exclusive right. Now, after the rule of discovery, this is what we're dealing with, is this aboriginal title, and I'm running out of room, and then you'll have a settlement. Treaty or statutory settlement. And then what do you have after the settlement? You have a species of reserved rights. In the Claims Act, it's fee simple land. They're not reserved. The land was reserved, but it was not reserved to a reservation. So reserved rights are rights that are acknowledged by the United States Congress and government to exist in the indigenous peoples now. Now, this is significant because aboriginal title, it is not a Fifth Amendment property right. And I can't even spell anymore. That is, the Fifth Amendment requires government to pay fair compensation for the taking of any property. But conveniently, in 1955, the United States Supreme Court, in the case coming out of Alaska, infamous case called Teton versus the United States, determined that aboriginal title is not Fifth Amendment property. It does not have to be compensated at the rate of, in the same way by fair market value and so forth as does Fifth Amendment property. That's convenient because it makes it very cheap to acquire aboriginal title. But once the land has been reserved under a law, I mean a statute or a treaty, then it is reserved rights and it is Fifth Amendment property. Which makes it very difficult to undo a treaty because you really would have to pay for the value of the treaty. So in the case of the Washington State Treaty Fishing Tribes, they had a treaty right to fish. Turned out they had a treaty right to 50% of the fish forever. So if one's going to extinguish that right now as a reserved right, you're going to have to pay a bunch of money to do it. And nobody wants to go there. So that's the key here, that once you get down to a treaty or recognize, and these are also called recognized rights by the federal government. Doesn't matter who else recognizes them, but the federal government recognizes those rights. So that's where you are with the Claims Act. You have recognized rights in this fee simple land, and if it would be taken by anybody, it's actually prohibited by the most recent amendments, but it would be by Fifth Amendment property compensation. I misspoke. It actually is subject to condemnation, I think, even now. Okay, now, trying to go on to, I'm well past the half hour mark. The major legal issues. Are there any questions or comments, though, at this point? You've had some great ones.
So just dropping down these other arrows, subsistence in this case under ANSA was
Yep.
now eliminated.
Yep.
And the sovereignty issues were silent.
Very good. I'm glad you're bringing that up. Yeah. That's good. Thank you. The only thing the Claims Act resolved, I think, was this. Land. Subsistence was extinguished by the Claims Act, and sovereignty was not addressed. So now that kind of frames some of the legal issues, too. I mean, the land issues are all kind of going to be resolved, they come up within the context of the Claims Act. I'm glad you mentioned this. It kind of gives you a different frame of analysis. So the land issues come up within the framework of the Claims Act. The subsistence issues come up, well, kind of outside the framework of the Claims Act, but now they get worked into with ANELP. So you end up with that difference. And then sovereignty is up in the air, but not so much because the courts have actually decided it now, and the Congress in 1993 Ada Deer recognized native tribes, and in 1994 Congress enacted the Indian Tribe List Act, which confirmed the action. So, and then you have a recent Alaska Supreme Court decision that concludes the same thing, that this settles the question of tribal recognition in Alaska, that the tribes are recognized in Alaska. These tribal governments in the list of 231 listed tribes are the tribes in Alaska. And I don't think there's any doubt now, legal doubt, that tribes exist in Alaska. They are the tribes on the list, the tribes that exercise powers of government. Now, we can talk about corporations as tribes. And they have to be tribes in some sense because that's what the Commerce Clause deals with. And of course, corporations have been listed or defined as tribes beginning with the Self-Determination Act of 1975, which defined tribes as any tribe, band and association and so forth recognized by the Secretary of the Interior, including, in Alaska, village and regional corporations. Now, but that recognition of the village and regional corporations in the Self-Determination Act, I think fairly read, is only for purposes of contracting under the Self-Determination Act. It does not, by itself, grant governmental powers to a corporation or tax exemption. Tribes are not subject to the federal income tax. They're just not listed. They're not described in the Internal Revenue Code as taxable entities. So they don't pay income tax on anything. Now, their employees do, but the tribes themselves are not subject to income tax. They can also pass laws, and corporations can't pass laws. So, I mean, I think there would be, that's kind of the big difference in the terms of tribes being recognized as tribes for federal Indian law purposes generally, and the corporations as tribes. And then there's a case, I don't have an exact site, but it's in the book, out of Seldovia, in which the Ninth Circuit and the DC Circuit both conclude that the corporations are not tribes for general tribal recognition purposes.
Is there a mechanism that a tribal organization or formal tribal organization of today, even if the Aboriginal title was extinguished, that they would try to renegotiate or redefine their land ownership relative to their tribal status?
In Alaska?
In Alaska.
No. I mean, except outside of the 3 mile limit. There's a continuing Aboriginal title claim. No, I don't think so. I mean, the US v. Arco says this claim was extinguished 3 different ways from Sunday. I mean, it was. It was extinguished as an Aboriginal title claim. It was extinguished as one that had ever been granted or recognized under statute or treaties. And it extinguished. Section 4, A, B, and C. So, yeah, I mean, I never say never, but I do in this case. I mean, there is no Aboriginal title claim in Alaska. Now, there may be other bases for, well, a lot of the question is how you kind of recreate what the tribes might have had. And, well, there's 2 ways I think this has happened, is happening. One is, which Venati and Arctic Village did immediately. They wanted to reserve, Venati and Arctic Village are up in the northeast Alaska, an area of a reservation, the area the size of Delaware, 1.4 million acres. The 2 corporations that were formed under the Claims Act immediately voted to transfer all the land to the tribe and disbanded the corporations. And that's stuck. I mean, that is what happened. You go look at the deed. They transferred the land to the tribe. So now the tribe owns the Anksa lands and governs it. Now, it's not a reservation, and they don't have complete sovereignty over it in the sense that the reservation tribe does, as the U.S. Supreme Court held, and in Venati, but they do own it, and they are de facto the tribal government of that area. And there's others have transferred the lands back to the tribes too. Villages have. In the case of Arctic Village and Venati, it was surface and subsurface that got transferred because they didn't take any other land under the Claims Act. The other thing that's happening, and I'm wandering a bit here, but we'll get back on track, is to do what I call retribalize or tribalize the claim settlement. Now, I'm not advocating this. This is a term I use to describe it. Is corporations which open their shareholder base to everyone who's a descendant of their original shareholders, eliminating the point that was made, perhaps, that you only have the people that were allowed to acquire these shares. That's the only ones that applied to. And in this respect, the Claims Act is a colossal failure. It was intended, if you're going to believe the words as they were written, as I've had them explained to me too by a staffer in Senator Jackson's staff, as you all know, the Claims Act was written to allow the shares to be sold in 20 years, in 1991. What was the purpose of that? You wouldn't have any question about whether the shareholders that had the Claims Act were the only ones eligible for it, and the others that didn't were not covered by the Claims Act. Nobody would have the Claims Act, or virtually nobody, if those shares had been sold and they available for sale in 1991. And people wanted, a rich buyer came in to buy it. Well, what would be the price of buying up 45 million acres of Alaska and putting it into somebody else's private ownership? Well, there would have had to be a buyer, and I bet there would have been sellers. And the Claims Act would have succeeded. It would have succeeded, as Doug Jones, the staffer I mentioned, said, and this is mentioned in the book too, it would have succeeded in normalizing the relationship, his word. You might say ethnic cleansing, but anyway, normalizing the relationships between the indigenous peoples and everybody else. It would have, if it succeeded in normalizing them in the way it always has, by expropriating the land, stealing it. And it didn't do that. It failed. And why did it fail? Because the Alaska Natives wouldn't let it happen. That's why. They went back to Congress and they got that sucker changed. So that now, in essence, they have opened the native claims to tribalization. See, the native claims did what the speaker told you it did. It took the land and the assets and created a communal property right of the Aboriginal community, of the indigenous peoples. A community right to private property. And it did it by taking that land, transferring it to corporations, which have a kind of communal ring to them, but they're owned by shareholders. And the shareholders have individual property. And believe me, that starts to change the way your brain cells work. So now people who own individual shares of property, dare I say, think of it as theirs. It's supposed to be paid dividends. It's my property. I don't want to give it away. I want it for myself. That's the danger of the claim. Well, I'm not sure that's a danger. But that is a consequence of the Claims Act, changing the way in which indigenous peoples think of their patrimony.
Was the ANELP Act more about the extinguishment of the Aboriginal right, or was it about the giving of land?
It is always about extinguishing Aboriginal rights.
Right.
It's always about that.
Because that's the control point.
Yes.
Because then you funnel everybody through your land law.
Yeah.
And then you give them land, and then they get land, but it's defined through that.
Yeah. And then how long is it before they've lost it?
Exactly.
Yeah. Sure. I mean, the Allotment Act in the 19th century resulted in the loss of 180 million acres of land, 2 Claims Acts, before it was all done. It's always about getting the land. You know, when you go to the archives to research Indian people, you know where you find them? There's no classification for indigenous people or Indian people in the archives. It's record group 75, public lands. That's where you find the records relating to indigenous peoples. That's the significance of indigenous peoples, to acquire the land. But not necessarily here, because indigenous people here have acquired control of a good deal of land and some very powerful institutions to control it and regulate it. So I do think in Alaska, indigenous people have a greater deal of institutional and control of wealth that has great potential for all indigenous peoples, but all for all Alaskans, if the damn state would just get out of the way sometimes. Anyway, I didn't say damn, did I? This is being recorded. So, the dang state. Okay. Now, let's see now. Okay, so I wanted to turn to what I call them the mega problem, the mega illegal issues that the Claims Act generated, and then the lesser ones.
While you're getting ready to draw another picture,
Yeah.
you had mentioned, so under you drew kind of a question mark dealing with sovereignty,
Mm-hmm.
but now through a number of different things that have happened, now here the tribes exist, and they have powers of government.
Uh-huh.
Tribes have, from the reading, it sounds like tribes have sovereignty,
Uh-huh.
yet they don't have a territory, they don't have
Yep.
reservation land, so it's
Yep.
you know, ineffective, I guess. It exists but hasn't.
It's not ineffective, but it is limited. More than if you can have sovereignty with and exercise the powers of government over many things without having to have territory over which to exercise it.
Right.
Okay. So we now know that, and this has been decided in the cases, and gradually, we now know that under Alaska case law of the United States of the Alaska Supreme Court, tribes have the power to decide divorces, domestic relations. John v. Baker. They have the power to decide adoptions, the Tanana v. Alaska case. And we don't know actually where that, I mean, John v. Baker is an excellent little primer on kind of the history and the potential scope of native sovereignty in Alaska without a land base. Yeah.
So does that, it's membership based
Yep.
versus land
Exactly,
based?
exactly right. Yeah, and there are two bases for,
Kind of
yeah.
get that concept.
Right, I know, and of course these, all these concepts, you don't find them in the grocery store walking down the aisle. I mean, they're just they're in our heads. We're making them up, but that's the law. I mean, so there's two bases for tribal jurisdiction, and they're independent: membership and territory. And you don't have to have both in order to have jurisdiction. And so it's very clear under the Alaska Supreme Court decisions now that tribes have jurisdiction based on membership. Now, how far does that go? What does it extend to? We don't know, but that's what's happening in the common law in this state. Now, that's interesting too, because this state is hostile in general to indigenous people. It's not for nothing that that Alaska is lumped with Alabama in the Voting Rights Act. There's a history of discrimination in this state that persists to today, notwithstanding the Supreme Court's decision recently. But and of course, my feeling is that the state just ignores, the Alaskan Natives are 1/4 of the GDP of the state. It's like they hardly exist in state policy. In fact, they're resisted, especially it depends on who's in the governor's office, but the current governor resists the existence of native sovereignty and its potential. The legislature may be more or less neutral on it, but it doesn't act very positively either. The only institution in Alaska government that is developing and has developed progressive policies and law for Alaska Natives' interests is the Alaska Supreme Court, and that all changed. Beginning, with John v. Baker, when the makeup of the Supreme Court changed and the majority started to write cases that were based on Indian law and not on a view of what they thought the law ought to be. They stopped acting like the legislature and started to act like the judges to determine the law. And the law leads you only one place, and that is membership is a basis of jurisdiction, territory is another basis, membership's enough, and for certain kinds of jurisdiction, you got it. That's it. It's pretty easy to write that opinion. It's just a few pages. Everything else takes more pages. The test for Indian law cases, the legitimacy of an Indian law case. I mean, keep in mind these are courts. They're not gods making these laws. They're courts. My test for the legitimacy of an Indian law case is it's inversely proportional to its length. The longer the decision is, the less likely it is to be a legitimate interpretation of Indian law. The shorter it is, the more likely it is to be an interpretation of Indian law, because it's really simple. Indian law is not complicated. Federal Indian law is not complicated. It is just ambiguous. And so it looks complicated because you want a certain answer. Well, I'm sorry, the common law takes a while to kind of evolve. You got to kind of read the tea leaves, predict where it's going. It's ambiguous. Now, you want complexity? Look at the Claims Act. That's complicated. Okay, now here are the legal issues that I'm thinking of. First we have, well, maybe a different color. We have what I call the mega issues that have occupied the most time in the courts and so forth. And they are sovereignty, subsistence, and subsurface, which has largely been resolved, I think. And I'm not sure that these are necessarily minor, but I'll call them other issues. My second grade teacher gave up on my penmanship. 14C. Well, I called 14H. No, there was easements, but that's not too important. Oh, I know. I really want to put down two. There may be others here, and if you have come up with them, let me know. Now, there are lots of other issues, I'm sure, between, well, here, there's one other set of issues. I want to call this, labor and civil rights. Okay, so this is kind of, many of you, several of you have kind of called this ahead of time, but these mega issues, one that was left unresolved with the Claims Act is, well, there are two of them really, but the sovereignty, and that has worked its way through the courts, federal and state, for the last, how are we, 30 years now? Or it's 40 years since the claim, 40 years, yeah. But these really began to work their ways through the state systems in 20, 30 years ago. And by John V. Baker actually the Tananaw case just last year, I think, and the action in 1993 and 94 to list the tribes and Congress's Tribal List Act in 1994 have really resolved this, well, the question of whether tribes exist in Alaska. Now, the scope of their sovereignty is what is now being litigated. It's up in the air. Congress could act or not, I don't know. But, and then you have situations like the enactment of the Violence Against Women Act, in which the state put it and was able to get a special caveat included to basically exclude Alaska, so that the tribes cannot take advantage of the Violence Against Women Act to protect Alaska's women from violence. That's what I mean. That kind of a policy, that the state and the congressional delegation went along with to exclude Alaska tribes from the ability to protect Alaska Native women, is a triumph of, to put it mildly, in its most polite term, ideology over her practicality. I am tempted to say that all these policies, to me personally, these policies that are opposed to Alaska Natives' legitimate exercise of some measure of self-governance, I think they can be founded on claims of sovereignty. But at the bottom, I suspect there's something else going on, a darker animus, if you will. But maybe this is not the time or place to talk about it. But so this doesn't make any sense that the state takes these kinds of positions, because in the case of that particular act and native sovereignty in general in those villages, that's the only government out there. The state of Alaska is not there. And so it's an abdication. It's irresponsible for the state, if it's not going to be there, not to facilitate the ability of the people who are there to govern themselves. And it is not any threat to state sovereignty. I mean, the state has plenty of sovereignty, and it's not going to lose it to the extent Alaska Native tribes have the ability to govern their own communities and the behavior that goes on there, and to control it, to control antisocial behavior. Yeah.
And I thought it was interesting from my perspective that there wasn't a huge debate. There wasn't a lot of discussion, and I don't know if it was that individuals just didn't understand the ramifications of that section and exclusion being included within the Violence Against Women's Act, because I mean, it really does put women and children and other people at risk. But there just wasn't any discussion after it passed, so I don't know, and there hasn't been any discussion since about correcting it.
Well,
You know,
I think
legislation, it can be amended,
Yeah.
all legislation can,
Yeah.
but it takes the will of the people to amend legislation.
well, and it may take the will of one or two people. And when anytime you see something like that happen with no discussion, it just comes out of nowhere, it's suspicious. You know, it is not government of the people, by the people, for the people. It's the government of some people for some other people. But it's not a more perfect union. And you know, anyway, but it's kind of a smoking gun of part of the real problem with the relationships between the state of Alaska and indigenous peoples. And it is wrong, and it's got to change, and it will change. It'll change over time. I mean, it changed with Georgia, for God's sake, and you know, it changed with Washington State. It'll take time, and biology. You know, biology takes care of all this. Frankly, you are all testaments to that. I'm a fossil, but you are the new generation, and there'll be another generation after you. And you're going to change things. Everybody will change things, and these policies will change as new generations come along. But they'll have to come along. Subsistence, you know, heck, that, you know, I think we all know. Well, I don't know the story, but where this goes. The problem was it was a mixed opportunity in the Claims Act to resolve fishing and hunting claims and to protect them, giving them meaningful protection. And it was wink, wink compromised. You know, the conference report said, "Oh, we can't deal with this, so we think the Secretary of the Interior of the state of Alaska will take all steps necessary to protect the subsistence rights of the native." Yeah, right. Well, that didn't happen. And come ANELP, there was an attempt to revitalize these subsistence rights, but you know, Congress listened to the whispering in the ear. Jay Hammond went to Congress and said, "We can't have exclusive native rights. That's against the Constitution of the state of Alaska." Yeah, it is. But there's a supremacy clause of the United States Constitution, which would have afforded Congress and does afford Congress the power to regulate commerce with Indian tribes to protect their right to hunting and fishing. It could have been done. And Stuart Udall at the time, and the Secretary of the Interior, was it Moe, said wrote a letter and said that the law isn't worth the paper it's written on unless it exercises Congress's power over the Indian Commerce Clause to protect hunting and fishing. Amen. It didn't, and this is what happened. It was a compromise that for rural resident preferences, which the Supreme Court of Alaska deemed unconstitutional under the Alaska Constitution because it wasn't mandatory. It wasn't something Congress mandated as an exercise of its power, and it couldn't. What power does it have over rural residents? So it doesn't have power to regulate commerce with rural residents. Congress doesn't. It didn't supersede the Constitution of the state of Alaska. And so the Alaska Supreme Court was free to say it's unconstitutional, and Alaska can't enforce the subsistence preference. Boom, now we're back to, a long time ago, back to federal management of subsistence on federal lands, and state management on state lands. And so it's pretty much screwed up, it's hard to figure out what's going on. Now there are some places in subsistence where Alaska Natives do have more or less exclusive control, and that's with marine mammals, because there is a federal law that provides that Alaska Natives have the right to take marine mammals and nobody else does for subsistence purposes. And that's a great law, because now what has happened? You have Alaska Natives who have formed co-management bodies, corporate organizations, nonprofits that manage marine mammals around the state, and not the state of Alaska. Now the subsurface issue, of course, it was on for decades in litigation until the Native leadership locked the lawyers out of the room and settled it. And so you have the 7I settlement agreement, which no, I'm sorry, that's a 7I settlement. Let me back up. The surface issues really got litigated, and I forget what I just said about the subsurface issues really got litigated as between beginning with Tyonek in 1988. So where was the subsurface? I mean, Congress passed this statute. It grants the surface to the village corporations and the subsurface to the to the regional corporations. But until then, there was no concept in the law of the subsurface estate. Nobody knew what it meant. I mean, there was the mineral estate. That's a well-established common law principle and a statutory principle. But nobody knew what the subsurface was. Where does it go? Does it include sand and gravel? How far down does it go? What is included in it? Nobody knew. And so it took years of litigation to figure that out, but the courts deciding it. Basically it means anything that was in the subsurface, at the time of the Earth's creation, is the subsurface. But if it ever was on top of the surface at some time in its existence, like a fossil, it is part of the surface. The fossils are surface, and sand, everything else is subsurface. Isn't that interesting? So next time we find a mammoth, it's on village corporation land. It's yours. But as far as the subsurface goes, then you have the question of, well, to what extent can a village corporation use the subsurface? That became without paying for it. Well, how does that, or can the region say you can't? We won't sell it to you anyway because we don't want you doing anything on your surface. We don't want you competing in your lumber business with our timber business. So we'll stop you from building the logging roads because we won't sell you the gravel. So anyway, that kind of stuff came up in Koniag versus Concord.
So David, dominant estate statute is primarily around the value of oil and gas, hard rock minerals, and those type of things, rather than anything else in the subsurface?
No. The subsurface estate is the dominant estate for sand and gravel. That's not a hard rock mineral. That's sand and gravel.
No, I understand that. I'm talking about other things. I mean, what you said earlier led me to believe that there wasn't a whole lot of subsurface law, for lack of a better description, prior to this.
But there's law about dominant estates and mineral estate, but the word subsurface is not a concept as far as I know in those laws. It's a word Congress used in the Claims Act, and it took decades to figure out what it meant by the courts, and the courts finally basically interpreted it to mean it's the dominant estate. Oil and gas, but sand and gravel wasn't included in the dominant estate normally, so that's included too in the meaning of subsurface.
Because I knew there was a lot of dominant estate law, I just didn't know the correlation between the
Right.
subsurface
Well,
and that.
exactly, and that's what the problem was. The Claims Act didn't correlate it. It didn't say dominant estate or the subsurface is equivalent to the dominant estate. It used a term, and it didn't say what it meant. And you might think that fossils were part of the subsurface estate, and I did, but they're not. So does that answer the question?
Does.
Yeah, okay. So in Concord versus Kodiak versus Concord, and you may be familiar with the case, but Concord well, I know some of you are, because some of you are part of the corporation that is part of, was or is part of Concord. But Concord was a joint venture of several corporations in the Kodiak region that harvested timber on their lands, and they of course needed sand and gravel that happened to be on the land because they didn't want to haul it in to put in the timber road, the logging roads. And they said, well, we can use it for free because we ought to be able to develop our lands, and we can't develop our lands and we can't use the sand and gravel. And Kodiak said, well, wait a minute, it's our sand and gravel. We can't give it, you can't just take it. And the court said, all right, we'll split the baby in two here. You can, Village Corporation, you can use sand and gravel for free as long as you don't move it more than 500 feet from where it originally was. So you can't have, a big borrow pit of gravel and take it 20 miles down the logging road and use it without paying for it. Then you got to pay a reasonable price to the regional corporation. If the corporation won't give you a reasonable price, come back to court and we'll tell you what the reasonable price is. So that kind of worked things out. So the corporation, Village Corporation, has to buy sand and gravel if it's going to use it more than for pushing it around, cut and fill it's called, or it has to pay for it.
Can I just give
Yeah.
a modern perspective?
Yes, do that. Give someone who knows what they're talking about.
So that's, our corporation was one of the corporations that were kind of involved in the issue with Kodiak, and here we are, years later, and now Kodiak is contracting with a Fognac to do their timber development.
I see.
So we've outgrown them as a timber development company.
Right.
So-
Oh, that's a good.
We're also putting all those gravel roads to bed, which is, right.
Yeah, you mean you're shutting them down? Yeah,
Getting
right.
rid of them, going back to the natural
Right.
habitat and reforesting the
Right.
area.
And you
So-
paid for them fair and square.
And we paid the lawyers a lot.
Oh yeah, you did.
We have some gravel if you'd like to buy it.
Well, and I mean, David Wolf was in my law firm, and he was litigating it for Concord. So, thank you.
So you just said that a fossil is not a subsurface.
Yeah,
So then what about fossil fuel?
fossil fuel.
Yeah.
I don't think you mean that's oil, right?
Yeah.
Yeah. I don't think we go there. I don't think we go there. It's oil, coal, and gas. They're all going to be subsurface.
Okay.
Yeah, they're a different category. They're kind of categorized as mineral estates. The courts have said the subsurface is the mineral estate, and so that's going to be mineral estate. I don't care where it came from. Okay.
So that's not a bad question, though.
No, it's a very good question.
Because
No.
I mean, they're even looking now at subsurface and the air that is around the particles. What is that? So it's all sorts of things.
Well, and what's the use of the air? What is that for? What are you doing for the air?
I think it's the argument between surface and subsurface.
Yeah.
Who actually owns it?
Legal settings.
So it's not over yet. Well, I take it back. I thought it was resolved, but it's not. Okay. So I think those are the kind of the mega issues of the Claims Act that are unresolved. We might debate whether they are, some of these are mega too. The 14C claim, this is the thing that the clause that says, find your most valuable land. Well, first it says give the land to the occupants of the land that, as of 1971. No, maybe that's okay. Then the 14C3, of course, says find your most valuable land and give it to the city. I mean, up to 2 square miles. And that's a real problem, frankly. But it can be negotiated thanks to the amendments to the Claims Act. You can negotiate that with a city to a lesser amount, and in fact down to 0. And I'll tell you, if you're interested in, as a matter of policy, in preserving the control of indigenous peoples of a community, that's what you should do while you got the chance. Is negotiate a 14C for the least possible amount to be held by the municipality or the trustee, because otherwise you are really opening the village up to 2 square miles of the village to non-indigenous control in the future. And it's a policy decision to be made now. Because once it starts to be, once the land is conveyed and the future comes, it'll be too late. So the Claims Act has, and this was another means of sort of normalizing relationships, so forth, so-called, between indigenous peoples and others. And you know, well, I happen to be an advocate that thinks indigenous peoples ought to be retaining as much of their land and control and authority as possible, because history, the only history is it gets taken away. So don't let that happen.
Are you referring to federal town site or 14C?
No, 14C. Now, federal town sites are a different matter, and
Although some people refer to those as 14C also.
they're not.
I know.
Yeah, yeah. So everybody know what a federal town site is? I mean, that's in the book. You can, but they are federal lands that are conveyed under a federal program, and that has now been terminated, and have resulted in, the town sites have resulted in some land being conveyed to the tribal governments in some 70 town sites around the state. Navigability is, I think, a continuing issue when it comes to some lands that are being conveyed to the native corporations, or whether they are going to have continued easements to a stream with running through a native piece of property, and it all depends on whether that stream is navigable or not. And the state will generally advocate that if you can float a wood chip down the stream, it can be navigated. Oh, the old saw is if you can float a Supreme Court opinion on it, it can be. And labor and civil rights is another issue that I think is getting some play, but basically tribes are exempt from the regulation of the National Labor Relations Board and the Civil Rights Act. So they are able to discriminate in favor of Native people and so forth in their employment and otherwise, but corporations are not.
But isn't there there's some case law, I guess, at this point, some decisions around the idea of whether that has to do with your ethnicity or shareholder status.
Shareholder status.
So you could say you give shareholder status because they're actually owners of the
Yeah,
company.
I think you can, as long as it's not as long as it's clearly not a racial
As long as
basis.
it's not
Right,
based
right,
on-
right. But
But doesn't that sort of erode the whole idea? I mean,
I guess it does. But see, it doesn't trouble me. But it does erode the idea that you're going to not have racial discrimination because the shareholders happen to be of a particular ethnic. But the point here is, and this is where it pays to split hairs. Indigenous people are not indigenous people by virtue of race. They are indigenous people by virtue of their political relationship, by the fact they are members of tribes or shareholders in corporations, I guess, and not because they happen to be of a particular racial background. And that's an important thing to keep in mind. I mean, the whole reason there is this ability of the United States to discriminate in favor of and against indigenous peoples is because they are of a political community called tribes with which the United States regulates commerce.
As long as that definition of tribe stays
What definition?
as described. If it's a political thing, it can be redefined.
Yeah, I think so. I mean, I think that Congress can call, the Supreme Court has said, as long as it is a distinctly Native community, Congress can designate it as a tribe, and it does not run afoul of the Constitution. And so, corporations are designated tribes. I think if you start to say, well, we're tribes for all purposes, the courts have held that corporations are not tribes for all purposes. They're tribes for certain, this cases comes out of Soldovia. And then there's another one in the D.C. circuit, and I've forgotten what that is, but it's also in the book. They're not tribes for political purposes. They're subject to the Civil Rights Act and the National Labor Relations Board.
Doesn't the settlement, I mean, it has that unique sentence around the idea of social, health, welfare, that piece of it for,
The settlement or ANELP? Or what do you
I'm
think?
talking about the Settlement Act, where it talks about the piece of that the corporations are entrusted to care for the, is it the education?
Is that, no, I don't believe that's in there. I mean, I'd like to see it.
I think that language is in the Indian Self-Determination
Oh,
Act.
Indian self.
I know what you're talking about, but I think that, I may be wrong, so don't quote me on film here, but I think it's included with the Indian Self-Determination Act.
Yeah, I wish I don't have the statutes to pull up.
There's also congressional testimony where someone said that ANCSA's original, or Congress's original intention in passing ANCSA was for corporations to care for the social, economic, and cultural well-being of Alaska Native people in perpetuity. And so I think at some point, somebody testified at Congress and made that statement, that that was the intention. And somehow we've interpreted that to mean that that's what the act says, but it doesn't state that.
No, the act doesn't state it.
In an amendment?
Well, it isn't an amendment. It's 14R of the Claims Act, and that is the amendment that allows the corporations to make distributions to their shareholders that are not equal distributions for their, and maybe this is what you're referring to, for their education, health, and welfare, and so forth. That is an amendment that was added to 14. I think it's 14R. I forget when. But it arose because corporations had bought life insurance policies for shareholders, and when the shareholder died, the corporation got the life insurance proceeds, and then there were other benefits being paid disproportionately to elders, and they got sued. They lost, and so the Congress amended the statute. Cake was a Cake Tribal Corporation, and they amended the Constitution to allow for non-equal distributions on just kind of an open blank slate. And now that's where I think that language may come from. But it's not a mandatory piece of language. It's not, and I don't think of Native corporations as having a mandate. I mean, a legal requirement to do social good. I mean, any more than any other corporation does. But they do, much to their credit, because that's who they are. And this. You know, there's a difference between, and as much as the Claims Act, I think, has changed the way Indigenous peoples think, and has the potential to change the way Indigenous peoples think, there's lots of evidence that Indigenous people still think like Indigenous peoples. I'm not one of them, so I don't know for sure. But I say this, and nobody's boos me and throws me out of the room, and so I'm going to keep saying it. And that is, look at what happened when it was possible to open the corporations to new shareholders without them paying any money on a non-capitalistic principle, on what I would call a tribal principle. It's more important to include everybody within the community of the corporation than it is to make profits or to protect the rights of the existing shareholders. So what happened? Arctic Slope, the Northwest Arctic Native Corporation, opened their shareholder role more or less indefinitely. Well, they were the first to do it. I thought, well, that says something about the way those folks are thinking up there. You know, that it's not so important to them that the individual property rights of the existing shareholders that were present with the Claims Act be preserved. We're opening up to everybody, and everybody's okay with that, and they had to prove it. The shareholders approved it by an overwhelming margin. Now there's, came along later, Doyon, bits and steps, and now they finally did the same thing. See, Alaska, I think, has essentially done the same thing now too, and some other village corporations have done it. But I think that is what I mean by that. To me, is a tribalization. It is a change in the mindset of what a shareholder is, to include everybody without there being a capitalistic motivation behind it. And the other thing that's happened, I think, as I mentioned earlier, is transferring land to tribes. Yeah.
So the piece that talks about real economic and social needs is Public Law 92-203, Section 2B.
Yeah, that's the Claims Act. Let me see. Oh yeah, well that's just a statement of purposes. What page are you on?
I'm on it's on page 41.
Mm-hmm.
Partway down it, and then if you go back to page 73, it cites where that's found, and it says Public Law 92.
That's the Claims Act. 92-203 is the Claims Act. 41, you said?
Yeah.
Where on that page? Can I just quickly,
It's the third paragraph down. It's
on the right-hand side there, you mean, or the?
right over, right here, about middle of the page.
Okay.
Second.
What makes me different, so different other business enterprises, they concern themselves with the real economic and social needs of natives. These very words are at the heart of the ANCSA. Well, okay, that's interesting, because I always read that as being the purpose of the settlement from the Congress's point of view, was to settle the claims with respect to the real economic and social needs of natives. But I never read that as being a mandate that the corporations had to. Now, what does it say about David Case? What does he say about that?
AJ definitely.
Okay, that's okay. That's okay. Okay, what?
AJ absolutely establishes your credibility there.
All right. Well, yeah. Okay. I believe all that stuff, all of those things that are said there. And AJ, yeah. I saw AJ just a few months ago. We paddled canoes together in Hawaii. Yeah. She's doing good. Yeah. All right.
So,
I think I'm done. So let's talk.
so on the note of civil rights and labor, it's also exempts Alaskan tribal entities from EEO and affirmative action, right? And so
What does?
the tribal status, but
Yes, that's exactly
that's an issue that is created through ANCSA because, at the time that was sort of, if you will, the tribal entity was considered, however you want to say that, however you said it was the best way to say it. But now that we have different case law that says, okay, no, you're not a tribal entity, then it becomes
Yes.
upon the
Yep.
Alaska Native
That's exactly right.
Organization to meet whatever requirements are EEO required.
That's right.
which
That's
is,
right. That's right. But the tribal status, because the tribes are, they're sovereign, so they have sovereign immunity. They are immune from suit. And that's the basic protection that they have that walls out enforcement of those acts unless they specifically apply to them. And so you're right. And but by definition, it doesn't wall out. There's no sovereign immunity for the other institutions, so they're not prevented.
So if I take that one step further, does that sovereign immunity fall to any organizations that the tribe creates?
No, but it can fall to them. It can fall to them. And there's an Alaska case that deals with this out of Bethel, and it begins with an R. It's versus the Alaska Village AVCP. Maybe it'll come to me. But anyway, yeah. And so the Alaska Supreme Court rightly has held that unless the actions of the tribally chartered nonprofit would impinge on the treasury of the tribes themselves, they are not protected by the doctrine of sovereign. The organization is not protected by the doctrine of sovereign immunity. And it really also helps that the organization is formed under state law, so it's a state chartered corporation, and that kind of suggests that it's not something that would impact the treasuries of the tribe. And it doesn't. I mean, the AVCP has other sources of funding. It doesn't get the sources of funding from the tribal governments. So, but if the organization were a tribally funded organization and that was the sole source of funds, and any judgment or something had to be satisfied out of the tribal treasuries, then so I think sovereign immunity would protect you. And Runyon is the name of the case. Runyon versus AVCP. I think Runyon acknowledges that.
Other questions?
Can you say the answer to that again one time? I'm trying to make sure I followed. The tribal sovereignty protects the tribes from suit related to EEOC. But if the regional corporations are not tribes, I don't know, but I assume they're currently operating as if they're not governed by EEOC.
Right.
That's true.
Well, they've argued in the part that in the past that they were governed by, they were not governed by the EEOC,
Right.
and then they've lost those claims.
And they lost that protection.
Right. I mean, the courts have held that the amendments to the Claims Act that exempted them from certain things didn't exempt them from what was the preference? Anyway, exempted them from a narrow part of the EOC, did not exempt them from everything else. And there's a section in the book on labor law, and now I can't remember what I said.
I have one follow-up question. You also mentioned that tribes are not, dealing with the sovereignty question, that tribes are not taxable.
Yeah,
So we have a whole bunch of tribes in this state.
yeah.
Does that mean from a now shifting over to the sort of the blended business tribal combo, is that a vehicle for non-taxable business?
Yeah, as long as the tribe is doing the business. And I think it could be even a subsidiary of the tribe. The IRA corporation or the tribe itself, for example, neither of them are subject to the federal income tax. Now, their employees are. They have to pay, they have to pay withholding and so forth. But they don't have to pay federal income tax on their income.
Even if they're doing business
They could be
elsewhere, let's say
doing
they're a
business, and
government
they could be doing
contractor.
business in South Carolina as a tribe, and the income from that is not taxable. Talk to your lawyer, but that's
I'm good.
yeah, right. But there's IRS ruling.
pretty interesting.
Yeah, I thought it should be. So see, that's what I mean. Tribes are some kind of a vehicle here. Oh, look, they could be an economic vehicle. You could shield income if you had the right kind of setup, maybe with the tribe and the. Yeah. Yeah, so, Indian law, I mean, what I'm talking about is mainly Indian law. The Claims Act is kind of Indian law, but it's really corporate law. But it's Indian law in the sense that its basic underpinnings are founded on these doctrines of Aboriginal title and its extinguishment. We haven't talked at all about sort of the underpinnings of tribal sovereignty, but that too is a common law matter. Are we familiar with this, the Cherokee Nation cases, and how those cases resulted in the determination that their tribes have inherent sovereignty? That's where it comes from. Well, in fact, I have a handout for it. And we have a couple of minutes. Maybe I'll just pass that around, and you can have that for reference.
So while you're looking that up, David, the current administration has put a focus on tribes too, giving them.
The federal administration.
Federal administration, giving them kind of a spotlight and opportunity.
Mm-hmm.
Anything coming out of that you've seen fresh and new as of the last?
Not that I've seen, but I'm retired in Hawaii, so maybe I don't see everything anymore.
He comes back for cameo appearances.
I come back when I was asked, and Greg asked, and a miracle must have lined up because I could get a ticket. I was originally planning to go to Portland from Kona to see my first grandchild, and I got this invitation from Greg, and I thought, no, I don't think I can make it. And I called Alaska up, Alaska Airlines, and they say, hey, can you do this? Guess we can. You can get there for half the miles and get there 12 hours earlier. Steve, this must be lining up.
I do want to say, just because you've heard the story doesn't mean you don't have to read the book.
So this is the opposite side of this. I actually started off with a handout for Cherokee Nation and Johnson versus McIntosh, and then I think, well, geez, I think the Constitution is probably more important. So this little handout summarizes the decision in Cherokee Nation versus Georgia. You got it, David. Okay. So this is Johnson versus McIntosh is 1823. This is 1831. And the Cherokee Nation had a treaty with the United States which set their reservation within 4 states, Georgia being one of them. And they had become one of the most successful, prosperous tribes in the country. They had prosperous farms, owned slaves, had developed a government that was modeled after the United States. And then gold was discovered on the Cherokee lands. And Georgia felt, well, this was time to step up and eliminate the Cherokee Nation. And by the way, in the course of negotiating the Constitution, the United States had agreed with the states on the eastern seaboard that if the states would give up their claims to their western land claims all the way to the Pacific, like Virginia and so forth, some states had land claims from their royal charters that would take it all the way to the Pacific Ocean, the federal government got those states to give up those claims if, in exchange for the federal government promising to peaceably remove the Indians from the eastern states. Another bargain promise that proved impossible to keep. So Georgia, growing restless over the failure of the federal government to peaceably remove the Cherokee and the fact of gold in their land, passed laws that eliminated the Cherokee. Said the Cherokee had no legal existence. Anybody could go there that wanted to, as long as you had a license from the state of Georgia. You need a license from the state of Georgia for any non-native to go on the Cherokee lands. And if you didn't get the license, you go to jail. So the Cherokee initially challenged the Georgia laws, and the Cherokee claimed they were a foreign state. They hadn't signed the Constitution. They weren't citizens of the United States. They were just like France or England. They didn't have any allegiance to the United States, so they were foreign. And therefore, they could have immediate, the jurisdictional statutes at the time, they had a right to go to the Supreme Court to argue as a foreign state against the state of Georgia's claims. And so this is what John Marshall says about this situation. And I mean, this is kind of what started the Civil War. This is a states' rights issue, and there was concern that the Republic was going to founder on this claim of Georgia, because it tested these laws of Georgia against the Treaty of the United States, which was the supreme law of the land. Council have shown conclusively that they are not, the Indian Cherokee, a state of the Union, and have insisted that individually the Cherokee, are aliens, not owing allegiance to the United States. And aggregated of aliens composing a state, they must say, must be a foreign state. Each individual being foreign, the whole must be foreign. This argument is imposing, but I'm going to get around it. But we must examine it more closely before we yield to it. The condition of the Indians in relation to the United States is perhaps, no, not sure, but perhaps, unlike that of any other two people in existence. In the general, nations not owing a common allegiance to others, are foreign to each other. The term foreign nation is, with strict propriety, applicable by either to the other, but the relationship of the Indians to the United States is marked by peculiar and cardinal distinctions, which exist nowhere else. Though the Indians are acknowledged to have an unquestionable and their heretofore unquestioned right to the lands they occupy, Johnson versus McIntosh, aboriginal title, occupancy, until that right shall be extinguished by a voluntary cession to our government, yet it may well be doubted whether those tribes which reside within the acknowledged boundaries of the United States, now that's crucial, they're unlike France and England, they're within the United States, with strict accuracy can be denominated foreign nations. They may more correctly perhaps be denominated, and this is the term from now on to define native sovereignty, domestic dependent nations. I mean, that's the common law, domestic law definition of tribal sovereignty from now on. They are domestic dependent nations. They occupy a territory to which we assert a title independent of their will, which must take effect in point of possession when it's extinguished, aboriginal title is extinguished, when their right of possession ceases. Meanwhile, they are in a state of pupillage. Their relation to the United States resembles that of a ward to his guardian. And that begins the rubric of guardianship and wardship and all that too. But what John Marshall really means by that is they are politically protected by the United States, and that comes out in the next case, Worcester versus Georgia, which is the next year. And in this case, the Supreme Court says, well, see, they're not foreign nations, so now we don't decide it. We don't have any jurisdiction over this case. Case closed. Theoretically, it doesn't mean anything because they have no jurisdiction to decide the case. But this is the fundamental principle of tribal sovereignty under American federal Indian law. The next year, Samuel Worcester didn't bother to get the license from Georgia. Went to the Cherokee Nation as a missionary at their request, was arrested, put in jail on his way to the Cherokee Nation because he didn't have the license, and he was breaking rocks in Georgia jail. And the Supreme Court couldn't ignore this case, so they had to decide. And they decided in Worcester versus Georgia that, yeah, the treaty is the supreme law of the land. The state of Georgia argued that, like under the Articles of Confederation, which preceded the Constitution, this was something the state was responsible for and had controlled. And Marshall reminded them, yeah, but that was the last Constitution. This is a new one. The Constitution affords the treaties, provides that the treaties negotiated by the United States are the supreme law of the land. Doesn't matter what your laws or your Constitution say. And so the treaty protects the Cherokee Nation from your law. It's illegal. You can't do anything about this. And to which Andrew Jackson in the presidency at the time has said, well, John Marshall has, supposedly he said this, has made his decision, now let him enforce it. And so it wasn't enforced. They enforced a new treaty on the Cherokee, Jackson's administration did, that then did remove them from Georgia through what's known as in the winter of 1839, what's known as, of course, the Trail of Tears, which thousands died on the way to a lovely place called Oklahoma, where the Cherokee reside today as the second largest tribe in the country. Indigenous people don't give up. And I think that's the history of the lower 48. And I'm sure that will be the history in Alaska. Thank you very much.